Have you been stuck in a situation where the buyer has terminated the contract within maybe even a day or two of executing the contract, but neither earnest money nor option money were delivered to the title company? Or have you represented someone who refuses to deliver that earnest money or option fee because they say they are terminating anyway? We went over the consequences of not delivering the earnest money and option fee in a few podcasts ago. However, this seems to be a question on repeat that we are getting from realtors for their clients. What does a seller do if buyer terminates a contract within what would be the option period, but there is no option fee deposited with the title company? Our response is always that the buyer did not have the right to terminate the contract under the option period if they did not deliver the option fee. The contract states, for nominal consideration, the receipt of which seller acknowledges and buyer's agreement to pay the option fee within the time required, seller grants buyer the unrestricted right to terminate this contract by giving notice of termination to seller within blank days after the effective date of this contract, the option period. It further states if no dollar amount is stated as the option fee or the buyer fails to deliver the option fee within the time required, buyer shall not have the unrestricted right to terminate this contract under this paragraph 5. So, if the option fee was not paid and buyer did not have a right to terminate the contract, what is the seller supposed to do? The seller wants the option fee. And to them I say, I agree. The problem comes down to whether or not the seller wants to hire an attorney, i.e. spend possibly a pretty penny fighting the buyer to bring them the option fee when the buyer is likely going to find a way to terminate the contract at a later date. The biggest problem here is that the contract is in full force and effect, even though the buyer tried to terminate the contract when they did not have the right to do so. Seller suing to collect the option fee, besides being very costly, also keeps the contract outstanding between the buyer and seller. In other words, seller can't fight this buyer and also go out and find a new buyer for this contract. The seller cannot contract with two buyers for one home. The seller will have to decide whether it is worth going after the buyer for the option fee and thus keeping the contract alive or terminating the contract so he can put it back on the market. The alternative is to recommend to the seller send the notice of termination for failure to deposit the earnest money to terminate the contract so he or she can put the house back on the market. However, what is vitally important is that the agents representing the buyers explain to their clients the importance of delivering the option fee when they know they are going to terminate. As I mentioned, when the buyer tries to terminate under an option period that they don't have, the contract is still in full force and effect. If the buyer gets sued because they did not close on the home, because they tried to terminate under the option period, for which they delivered zero option money to have an option period, my guess is that the judge is going to look favorably upon the seller, and the buyer is going to be out of luck, and the court will require that the buyer pay their own attorney's fees, pay the option fee, damages to the seller, and the seller's attorney's fees. It is imperative that the option fee and earnest money are delivered within the time required under the contract. We love any input or suggestions for our tip. Please email tipoftheweek@allegiancetitle.com. We would also love to be your resource for results, especially at the closing table.